session.
Thank you, Ms. Clark. And on behalf of Judge Stafford and Judge Bennett, we welcome counsel who are participating in this live streaming oral argument. We will conduct the hearing in the same fashion as if all of us were in the courtroom together. Each side has 15 minutes to argue, and the appellant has reserved 5 of his 15 minutes for rebuttal. Unless there are announcements, we will ask Ms. Clark to call the case.
Candes Prewitt versus St. Thomas Health.
All right, thank you, counsel. The floor is yours.
Morning, Your Honor. Just like to first touch the issue of the facts and how they were interpreted. Opposing counsel did say on my brief that I did include a lot of facts that weren't on the record, and I probably did. I thought I was putting it into context, but to the language of the complaint, I'd like to point out paragraphs 6 and 7 are the ones that put the time period in place. We're discussing the discovery rule, and the trial court believed that my client had already discovered the tortious injury before my client believed she did, and the court thought that it was discovered in late January. The language of the complaint speaks of my client keeping the birth of her child private, and that in late January of 2019, she received documents that included the date of her cesarean section that took place at St. Thomas Hospital. I believe the cesarean section is synonymous with the birth date. It doesn't really, on the face of the complaint, it doesn't say in detail if they were medical documents or the nature of the documents that were known. And moving on to the next paragraph, my client wrote in her complaint that she placed a phone call in order to ascertain. And in order to ascertain, I believe that means that what had happened wasn't very clear to her. My client
isn't the standard of that you don't have to know all of the facts, but as long as you're put on notice, sufficient to justify an inquiry?
I believe in the case the opposing counsel cited to the Red Wing case shows that it's synonymous with inquiry notice, but in my review of the medical malpractice cases, it doesn't seem to follow that. For instance, in the cases that I cited to in my brief, in Foster versus Harris, that had to do with a guy that had contracted hepatitis from a dentist office, and the dentist cut his finger and bled into his client's mouth, and the plaintiff in that case was not put on inquiry when he was aware that he was diagnosed with hepatitis, and at that point he had knowledge that he received blood into his mouth from the dentist's hand while he was receiving treatment. And when he had the diagnosis, along with knowledge that the dentist cut himself, in that case, he was not put on inquiry. In the Hoffman case, that plaintiff was having pain after a medical treatment and was not deemed to have been put on notice at the time that she made the appointment to get a second opinion. At that point in time, she was thinking there was a problem, and the court did not hold her to have been on notice at that point. And Shadrick versus Coker, the plaintiff had a back surgery, 2 follow-up surgeries, and it was 3 years had passed, including 2 follow-up surgeries. And I think a reasonable person would be on inquiry that there was a problem with the first surgery if it required 2 follow-up surgeries and he was in pain for years. So to be on inquiry, I don't think that that standard has been followed in the medical malpractice cases in the history of the court and how these cases have been developed.
Well, she sent a letter.
I'm sorry, Judge Bennett, go ahead.
She sent a letter to the Department of Health and Human Services about her medical records being improperly accessed or released. Wouldn't she have been on notice doesn't that letter show evidence of that she knew something was going on?
I think at that point it was a suspicion that there was a possibility, but she had never confirmed it. In these cases, part of the standard says that people.
You don't have to confirm it, do you?
My client had never confirmed exactly what happened even until this day. In the medical malpractice cases, especially the court had quoted that in the dismissal to those line of cases, people at least get an idea of what's happening. My client.
Is this a medical malpractice case or an
No, it's
invasion of
not.
privacy?
It's an invasion of privacy case, but a lot of the leading cases involving the discovery rule are medical malpractice cases that I've read.
True.
And the court had quoted to those in her opinion in the dismissal. So I followed those line of cases because I believe they were relevant if the judge used those as the basis of the dismissal. And so I believe there was at that point maybe a suspicion, but no real knowledge. It was just a mere possibility. I believe on the complaint, the language could either, she says a cesarean section in paragraph 7, but that's synonymous with the birth of a child. I think it could be interpreted in a way that the document contained a birth date and the birth date was private and she didn't know how it happened. And it was a possibility that someone discovered the birth date through her medical records of her cesarean section because those are synonymous.
You're saying a birth date is a private matter?
No, I'm not. I was saying my client was, from the complaint, the document she received contained the date of her cesarean section, which is synonymous with the birth date. It's in paragraph 6 right before that. She mentions the birth of her child. So I don't know if it's clear that she, from just the language of paragraph 7, what the nature of that document was, if it was a copy of a medical record. It doesn't say that. It says a basis of why she suspected it could have been, and she went on exercising reasonable care and due diligence. As in the line of medical malpractice cases, most of the people would have some sort of a pain after a procedure, and they were allowed to do some sort of investigation. I believe in the Shadrick versus Coker case, when his cause of action accrued was when he was watching a television program that talked about the defective nature of the screws that he had in his back. And he had 2 follow-up surgeries, and it was a couple years of time when he was in pain after follow-up surgeries. So he had time where I think a reasonable person would have thought, hey, maybe there was a problem. And the court didn't hold that man to be accountable to have to sue on just a mere suspicion of a possibility. He was allowed to sort of do a little bit of follow-up to try to figure out what happened.
Counsel, let me ask you a question. A moment ago, you said you still don't know what happened. Do we even know that your client has suffered an injury here?
An invasion of privacy is what she's alleging.
I understand what she's alleging, but I'm trying to wrap my arms around the mere allegation that somebody may have disclosed something, but what can you prove, I guess, or what can you show by way of the complaint?
Way of the complaint, she was informed when she got the letter back from the Office of Civil Rights that there was a matter and it was going to be resolved informally. That's what the letter said. So at that point in time,
I'm not sure what that means. Can you enlighten me a bit?
My client was inquiring into whether her medical records had been accessed without her knowledge. She didn't get a response from St. Thomas, and then she filed a letter with the Office of Civil Rights, and in their return letter, they said there was a matter. At that point, my client believes that there was something going on with her medical records there.
Okay.
So was she on notice when she received the letter from OCR?
I believe so. At that point, she'd exercised reasonable care and due diligence. She did what she could, and she received a letter saying that there was a matter.
Okay.
Time is about up. I'll yield the floor to opposing counsel.
All right, thank you, sir. We'll hear from you on rebuttal. Counsel?
Yes, Your Honor. May it please the court, my name is Paige Burnick and I represent the appellee St. Thomas Health in this matter. The trial court correctly dismissed this case based on 2 grounds, based on the particularity rule, as well as the statute of limitations issue. I'm going to address 2 issues here today. First, whether the appellant waived her right to appeal the particularity rule ruling by failing to address it in her brief. And second, whether the trial court correctly dismissed the case based on the statute of limitations issue. I'd like to add a few facts that counsel has brought up in addition to his recitation of the facts, Your Honor, if it pleases the court. The issue, the appellant had a cesarean section at St. Thomas Midtown, the hospital, in December. She, in her own words in paragraph 7, learned that this information, private information that she claims was disseminated by an unnamed man, not by an unnamed man, but to an unnamed man. There's no indication of who did this action or how this person's connected. And then she started to make phone calls and eventually writing a letter, and she got a return letter after this investigation took place in January, or notice took place in January. She filed her complaint based on an invasion of privacy claim on February 5th, 2020, which was 1 year outside that January 2019 awareness of what was going on, or dissemination. We filed a motion to dismiss in April. This was heard, and the trial court specifically dismissed the appellant's claims on 2 separate grounds. First, yes, the statute of limitations issue, but also dismissed the issue or the claims based on the particularity rule. And I'll start there. The appellant waived her right to appeal the particularity ruling by failing to address it in the brief and in the statement of facts. Under Rule 27A of the Appellate Rules of Procedure, when matters come up on appeal, it's not just a mere technicality. The appellants must bring up this issue in their statement of the issues under 27A4, as well as in their argument section under 27A7. And this is found by the Snead case, the Supreme Court case, where the Supreme Court said that issues, you can't have a blanket issue, you have to be specific, and you can't dig around. The court isn't there to dig around for issues that weren't brought up on appeal. And this is also discussed in the Court of Appeals case in Cartwright, making sure that 27A4 is not a mere technicality in a brief. Counsel must bring up these issues on appeal to address them on appeal. And here the appellant is not. There is no discussion in the statement of issues concerning the particularity ruling, the independent ruling that the trial court dismissed this case, and there's no discussion in the brief section, argument section, about the particular ruling, and frankly, no discussion yet here today about the particularity ruling. So as there is no discussion, she has waived that rule, and that was an independent finding by the trial court under Rule 8.01 that she failed to plead with specificity. So at this point, I think the analysis here, because of that, we wouldn't even need, the Court of Appeals wouldn't even need to address the statute of limitations issue, because the appellant has already waived her right to appeal the other grounds that the trial court found to dismiss this case. But even so, I'll address the statute of limitations issue next. The trial court correctly dismissed the appellant's claims under the applicable statute of limitations based upon the four corners of the complaint, and gave her a very liberal view of what the time limit was in her accrual of the action. Again, in her own words, the appellant plaintiff pled in paragraph 7 that she learned that this information was disseminated in or around January 25th. And then the following paragraph, she describes that she started to investigate the claim. So she was on notice that this information, this invasion of privacy, took place in January. And the trial court in the ruling noted that they gave her the very last day of January. She wasn't specific, but gave her January 31st, 2019 as the date that the action accrued. And her actual action complaint was submitted on February 5th, 2020. Plain and simple, outside that 1 year statute of limitations. Next, I know that counsel has brought up the discovery rule, but the trial court still, I believe, applied the discovery rule in Tennessee correctly. Again, he's brought up these medical malpractice cases, but this isn't a medical malpractice matter. This is a invasion of privacy claim. And in the Red Wing, the Supreme Court determined that it's not, a plaintiff can't delay her claim till she knows everything and all the facts. It just tolls, the discovery rule just tolls that action date until they know that there is a harm. And here,
counsel, which paragraph or paragraphs in the complaint do you rely upon to establish her discovery, or that she knew enough to justify the inquiry? Which of the paragraphs in the complaint do you rely on?
Yes, Your Honor. I like to look at paragraph 7, where she said that she actually stated that the information was disseminated to a violent and abusive man in late January 2019. And then the following paragraph, she identifies that she started to contact St. Thomas Midtown, the hospital, about the issue. And then later that she wrote a letter. But what she didn't say is the date that she wrote the letter, but it's presumed she already knew of the harm because she was investigating her claims and noted the date that it was in late January 2019.
That she wrote to St. Thomas, was that related to the Civil Rights Office response, or was that separate?
That was a separate issue, Your Honor. I believe the way she put it in the complaint is that she made a phone call and then she made a letter to OCR, the federal agency of the HHS, to make a complaint. And then later on, she wrote a separate letter to St. Thomas about the issues. But I believe that was later on in her complaint in April. But that's still...
And in any event, your position is these paragraphs establish that she knew or should have known of a claim prior to February the 5th of 2019.
Correct, Your Honor. And I believe she did, because she puts in the complaint, she states in the complaint that she learned that this information may have been disseminated or gotten to the hands of this unnamed individual. And had put her on active notice. And under Red Wing, we're not looking actual notice, or we're just looking at, well, it can be actual notice or inquiry notice. And I believe here, this is inquiry notice. This is a reasonable person investigating their claim, in which she did. she's acted accordingly. She learned that this information had been disseminated, and then like a reasonable person started to ask, and we see that in her own words. So under Red Wing, I believe that she was already on notice that her claim began to accrue in January of 2019. And again, as page 459 in Red Wing states, you don't have to know all the facts, and you don't have to know everything to delay the accrual date. You just have to know that a harm is there, and you have to start being a reasonable person to investigate. And again, here, this is what the appellant was doing at this time. Again, this is separate from, this is invasion of privacy claim is separate from the medical malpractice claims that they rely upon. You know, she knew this wasn't a complex medical issue. This was something that an invasion of privacy and facts is something that a lay person could know immediately that the harm was done. And that's why she was on that constructive notice at that time. So based on those facts, the trial court correctly applied the discovery rule and gave the plaintiff every opportunity and a liberal reading of her complaint, but still correctly dismissed her claims under the 1-year statute of limitations. And the trial court's decision should be upheld.
All right, thank you. Anything further?
No, Your Honor, for all the foregoing reasons here today in the brief and in the record, we ask that the appellant's claims be, or the trial court be affirmed and the appellant's appeal be dismissed with cost tax to the appellant. Thank you.
All right, thank you very much. We'll hear from rebuttal.
I'd just like to point out again.
I'm having difficulty hearing you.
Oh, I'm sorry, I'll speak up.
Sure.
In the complaint, I don't believe it's clear what was found out. It says there was a date in the document that included the date of a cesarean section. It mentions the birth of her child, and if the complaint was read that they're synonymous, if it was just a birth date, it would not have shown that that came from St. Thomas. Later on, after figuring it out, at that point, I believe it was just a mere, maybe a suspicion with no, I don't think someone would have a good faith basis to justify going to court and filing a suit when they just have kind of a hunch. I believe that's why the courts frequently talk about the reasonable care and diligence. I don't know how someone could exercise reasonable care and diligence while being completely unaware of something.
Isn't that why the law gives the plaintiff a year from that hunch, as you call it?
Could be when they receive a reason to have inquiry that a tort had occurred and the tortfeasor. How to identify the tortfeasor, I think, is the issue I'm getting to, because she found out there was a date. How did the person find that out? Did it come from St. Thomas? Then she goes on and she researches, just like in the line of the malpractice cases. All those people had a hunch, and when they had a hunch, they weren't held to have been on notice or to have inquiry notice. They did a little bit of investigation. And here I believe that the date of February 6th, when she got the letter back, that was her first real solid indication when she could have had a good faith reason to go to a court and to file. I believe that's what I'm getting to with this here, that the medical malpractice cases seem to not just show that when people have a hunch, and I know this isn't medical malpractice, but most of the leading cases that came up in my research use these situations to apply the discovery rule in most of the facts. And people usually do have a way to go and find out what had happened, at least to get a hunch of who did it. They talk about not just knowing there was an injury, but who the tortfeasor was. Also, lastly, I'd like to briefly touch the particularity issue. most cases, the particularity issue, if a case is dismissed for that, it's solved by an amendment. And it's very easy. It's not lethal to the case. The main issue of this is the statute of limitations issue. Without the statute of limitations issue, it wouldn't be a full dismissal. It would be just a simple amendment, and it would be right back into court. The particularity there is probably in the middle. Probably reasonable people could disagree. There were the way she wrote the thing with the statutes was a little unclear, but I think it could.
Where in the appellant's brief is that issue raised to challenge the correctness of the trial judge's dismissal of the claim for failure to state with particularity?
I didn't raise it because I thought that it would be usually a non-issue solved by an amendment. If we went on the issue of the discovery rule,
the appellant's brief, or
if the court rules that my client filed within the statute of limitations, the particularity requirement is just solved by an amendment if it gets remanded.
well, the trial court dismissed it for failure to state a claim with particularity. So you're saying you can ignore that and we can ignore that?
I believe if you find my client's cause was filed within the statute of limitations, it could be remanded and held not to have been properly dismissed at the time. It would be remanded and we could amend. That's how I took that to be.
So we're supposed to ignore a ground upon which a trial court dismisses a complaint.
Because the remedy for that is usually not a full altogether dismissal forever. It's usually
How's that a remedy if it's a final judgment?
you seek leave to amend. Usually that's how it works in my experience.
All right, your time is up. Thank you both for your arguments, and we will take this matter under consideration. Ms. Clark?
The Honorable Court of Tennessee is now in recess.